Two people can walk into court and tell the same story. One is believed, the other is not. Why? Because in court, truth is not only about what happened, it is also about whether the judge can trust you as a source of information. Today we are discussing things you should do when giving evidence in court, so your evidence is more likely to be considered clear, reliable, and credible. Number 1, be consistent. A judge listens for consistency, like a doctor listens for heartbeat. Your evidence should line up with your affidavit, your documents, your previous emails, text messages, and what you said earlier. What kills credibility? Changing details, adding new facts late, and contradicting documents. If your story keeps changing, even on small details, the judge may think, which version am I supposed to believe? Minor mistakes are human, but major unexplained contradictions are dangerous. Number 2, be prepared. Do not walk into court hoping your memory will magically save you. Before giving evidence, read your affidavit, your statement, key emails, contracts, dates, invoices, bank records, and important numbers. If you are a business owner, know the basic figures. Don't turn up knowing nothing or letting people find out that you don't even know if the business made a profit or loss over the past 3 years. If you are talking about a meeting, know the date, who attended, and what document followed. Preparation does not mean rephrasing fake answers. It means knowing your own evidence. Number 3, behave with confidence, firmness, and respect. Demeanor still matters. Judges are cautious about judging people only by appearance, but how you behave still affects whether you seem reliable. Speak clearly, sit properly, stay calm, do not mumble. Do not roll your eyes, do not laugh sarcastically, do not look like you are fighting everyone in the courtroom. Confidence is good, arrogance is not. Firmness is good, aggression is not. Number 4, be truthful and answer the question. Credibility is not about sounding confident, but sounding honest. The fastest way to damage credibility is to avoid the question. If the lawyer asks, "Did you sign the document?" do not answer, "Well, let me explain the whole background." Answer first yes or no, or "I don't remember." Then explain only if necessary. A direct answer makes you look honest. Avoidance makes you look like you are hiding something. Number 5, look at the judge when giving evidence. Here's the truth most people don't realize. Judges don't feel credibility. They test it by observing how you approach and respond to the questions and the pressure. When answering, especially on important points, direct your answer to the judge. Eye contact is very important. When you look at the judge while speaking, your facial expression also conveys a great deal of information. The lawyer asks the question, but the judge is the person deciding whether to believe you. Do not stare aggressively. Do not perform. Just remember, your evidence is for the court, not for the opposing lawyer. Number 6, keep your answers short. Short answers are safer. If the question is, "Were you at the meeting?" the answer is yes, not a 5-minute history of the dispute. Long answers create 3 risks. You may contradict yourself, you may open new issues, you may look like you are trying too hard to persuade. Answer the question, then stop and wait for the next question. In rare circumstances, you may be asked to expand your answer or provide more information. This usually happens where the court is specifically interested in certain key details. Then it's a good time to build your credibility by providing the requested specifics. But again, focus on what has been asked and don't stretch too much. You are still answering questions, not telling the story. Number 7, do not argue with the lawyer or the judge. The opposing lawyer is not your enemy. Their job is to test your evidence. If you argue, interrupt, or become hostile, the judge may think you are defensive rather than reliable. Some witnesses get angry with lawyers' questions, but strong emotions don't strengthen your evidence, they weaken it. If you feel emotional, pause before answering. Take a moment to collect yourself. You can ask for a break if you feel that you could not control yourself. Also, never argue with the judge. If you disagree with the question, stay calm and say, "I don't agree with that. That is not how I remember it." Or, "I cannot accept that suggestion." Be firm, respectful, and controlled. Number 8, do not pretend you know everything. Courts prefer reliable witnesses, not perfect ones. No one remembers everything perfectly. If you say you remember every date, every word, every meeting, and every detail from years ago, that may look suspicious. Judges do not like witnesses to reconstruct their memory to prove their own stories. It's the court's job to connect all the dot points and solve the puzzle. So do not guess, speculate, or try to help the court with the missing pieces. It's perfectly acceptable to say, I don't remember, I'm not sure, or I will need to see the document. What you must never do is make up facts to fill the gap. A witness who admits limits often looks more credible than a witness who pretends to be perfect. Number 9. Do not discuss your evidence while you are still a witness. This is critical. If you are still under cross-examination, or you have not finished giving evidence, do not discuss your evidence with others, including family members, friends, or people involved in the case. Why? Because it can create concerns about collusion, coaching, or contamination of evidence. Each innocent conversation can look suspicious. If you are unsure, ask your lawyer about what you can or cannot discuss. Number 10. Think carefully before using an interpreter. If you genuinely need an interpreter, use one. Accuracy is more important than pride. But do not use an interpreter as a tactic just to gain thinking time. Some witnesses can speak English, but still choose an interpreter because it gives them more time to process questions. That can backfire. The judge may prefer to observe your immediate reaction, tone, hesitation, and direct answers. Some of that can be lost through interpretation. So the real question is, do you need an interpreter to give accurate evidence? If yes, use one. If no, think carefully before creating an unnecessary barrier between you and the court. Judges assess credibility based on internal consistency, logical plausibility, demeanor, and most importantly, whether your story matches the documents presented. Credible evidence is not dramatic, it's discipline. So remember, be consistent, be prepared, be respectful, answer directly, look at the judge, keep answers short, do not argue, admit what you do not know, do not discuss evidence while still being a witness, and use an interpreter only when genuinely needed. In court, the best witness is not the loudest person, it's the person who is clear, calm, honest, and reliable. If you were giving evidence tomorrow, which of these would be the hardest for you? Let me know in the comments. Thanks for watching. We'll see you next time.